course, a motorcycle goes by. Hi, everybody. John Semankiewicz with Beer Law Center. Once again, my far more technically savvy associate, London Davenport, has forced me to do another video for Instagram and the social media web and so forth. But it's kind of great. Other than staring into this incredibly bright ring light, I'm excited to talk to you today. I'm going to talk to you just a couple of minutes about non-compete agreements and non-solicitation. I'm going to keep it pretty short because I don't want to waste your time too much. I get a lot of questions about non-competes, non-disclosure agreements, and non-solicitation. So here's the thing. To be enforceable, you have to bargain for the non-compete. So in order for it to be enforceable, you either have to have them sign it as part of the job offer, or you have to give them something else, something extra. So if I've been an employee for your company for, I don't know, 5-6 years, and then one day you come to me with a non-compete agreement and say, here, sign this. If I just sign it and you don't give me something in exchange for that, it's not enforceable. So we always recommend to clients, make it part of the job offer. Part of your job offer is this non-compete agreement. And that's true of non-compete, non-disclosure, and non-solicitation. Let's talk real quickly about non-competes for just a second. Non-compete agreements have to be reasonable in 3 areas. They have to be reasonable in geography, scope, and duration. I think about those as sort of a leveling test. If you have a really wide geography, like the entire country, then you better have a very short duration. If you've got a really broad scope, like, hey, you can never work with anybody, or you can't work with anything having to do with alcohol at all, well, then you better have a very narrow geography. And the idea there is that it's designed so you don't strip somebody of their livelihood. They can't compete with you, but they can still go make a living. So for example, I work with a lot of breweries and especially with, like, for example, head brewers. We say, okay, the non-compete is you can't work as a head brewer or as cellarman or packaging or something like that on the production side within, like, maybe, let's say, 60 miles of wherever you were for maybe a year. Okay, so we got a year, 60 miles, no brewery work. That still leaves open things like you can open a bottle shop, you can go work for a supplier, you can go work for a distributor. There's other things people can do to make a living still within alcohol or within beer sales in that situation. But if you start saying, okay, well, you can't work in anything with being a brewer or production for 2 years, well, now you better make the geography a lot smaller. I often, again, recommend to clients about an hour's drive. So depending on where you are, that may even be a different state, but maybe an hour, 2 hours drive. What are you worried about them taking away with them? For example, running a bottle shop is a completely different set of skills than being a brewer. If they go open a bottle shop, are you really concerned about that? If they go open a restaurant, are you really concerned about that? If they go open a brewery making beer like you, okay, that may be a problem. So think about what it is you're concerned about, and then how far. It's probably not reasonable to prevent somebody from working in their chosen field anywhere in the country, right? So if you're a North Carolina brewery, just for example, and you say, hey, you can't work as a brewer anywhere in the United States, well, it better be a very short duration, because that seems like a lot. So it's got to be reasonable in those 3 things. To some extent, the same analysis applies to solicitation. And specifically when we talk about solicitation, it's about either soliciting customers or soliciting employees. That non-solicitation is, hey, you work for me. When you leave, you shouldn't be able to come poach my employees or poach my customers for at least some period of time. So this ties pretty closely to the non-compete, but it's a little different. For example, even if somebody, let's take that brewer example. They're a brewer, they go open a bottle shop because they can't be a brewery because they're non-compete, but then they hire your 3 best taproom managers or taproom folks. Well, that's just kind of poached your employees. So you do have to be really careful, but you have to look at it from again, is it reasonable? Are you depriving somebody of their livelihood? And is it something that you can enforce if you need to? So anyway, that's my 30-second spiel on non-competes, non-solicitation agreements. If you have any questions, give us a call. Follow us on social media at Beer Law Center. Thanks a lot.